Veuillez prendre place. Je vous remercie. Donc, à partir de cet instant, je vais donner la parole au modérateur de la cérémonie, son Excellence Blaise Chikaya, vice-président de la Cour africaine des droits de l'homme et du peuple. Excellence, vous avez la parole.
Merci, cher Monsieur Diallo, greffier adjoint de la Cour. Nous allons poursuivre donc le programme de la journée. On va commencer par le point 3. On va appeler la présidente de la Cour africaine, son Excellence Imani Aboud, de pouvoir présenter son discours de bienvenue. Madame la Présidente, vous avez la parole.
His Excellency Harun Al-Suleiman, Minister of State, President's Office, Constitution, Legal Affairs, Civil Service, and Good Governance. Representing His Excellency Hussein Mwinyi, President of the Revolutionary Government of Zanzibar. His Excellency Solomon Ayele Deso, Chairperson of the African Commission on Human and People's Rights. Honorable Justice Blaise Chikaya, Vice President of the African Court on Human and People's Rights. Honorable Judge Michael Ajaka, Chief of Staff of the Minister of Justice and Keeper of the Seal of the Republic of Benin, representing member states of the African Union. Honorable judges of the African Court, honorable colleagues, judges of international, regional, and national courts, distinguished participants, ladies and gentlemen. I welcome you all to Dar es Salaam, the city of peace, and now, for a couple of weeks, the capital city of African human rights justice. Allow me, as a matter of tradition, to extend the court's gratitude to His Excellency, the President of Zanzibar, who has designated the Honorable Minister of Harun Ali Suleiman to grace this event with his presence. Your Excellency, please accept and convey the court's appreciation to His Excellency, the President, for having hosted our four-week session in November 2019, and agreeing again to host the very important forthcoming retreat between the court and the Permanent Representative Committee of the African Union, slated to take place in early December. Excellencies, distinguished colleagues and participants, it is largely agreed that the main rationale for any justice system in the enforceability of the outcome of the dispute that the parties bring before a competent body for adjudication. There lies the justification for the maxim of obius ib remedium, which postulate that where there is a right, there should be a remedy to vindicate that right should a breach occur. This major principle of justice is betrayed if the remedies exercised remain without effect on the legal situation brought for resolutions. It follows that regardless of the legal system, the country or the parties to the dispute, it is the very legitimacy of the adjudicatory body that comes under threat every time a judicial decision is disregarded. It is recognized of this imperative of the rule of law that the African Union lawmakers conferred on the decisions of the African Court, both the binding character and enforceable nature through Article 30 of the protocol establishing the court. The fact that only 7% of the decisions so far delivered by the court, by the African Court, have been enforced is therefore alarming, as it betrays the aim pursued by the member states of the African Union while establishing the court. It is so because states envisage the court as an essential link in the achievement of the continental integration project contemplated by the founding fathers of the African Union. Your Excellencies, ladies and gentlemen, distinguished guests, I welcome you all to the International Conference on the Implementation and Impact of the African Court Decisions. The conference that begins today should have taken place 2 years ago, but was postponed for various reasons that I do not think it is important to recall here. What I do think is important, however, is that the successive postponements have caused the conference to be held this year and this month. At a very opportune moment in the history of the African Court. Indeed, this conference could not have been held at a better time than now, when the African Court is facing the most important challenges of its existence. As the court celebrates its 15th year of the operation, barely 1 in 10 of its decision is enforced. A less than modest 6 of the founding members states recognize its jurisdictions, and only 31 of the same states recognize the court's operational existence altogether. This picture does not honor Africa. It does not honor member states of the African Union. It does not honor the African Court, and it does not honor Africans. Besides, you will agree with me that by the nature of the norms, it applies the very mandate of an international court. It is indeed to enforce and harmonize the interpretation and application of international laws in the national systems of the member states that have consented to the particular regime involved. In this regard, it is worth noting that 54 of the 55 member states of the African Union have ratified the African Charter on Human and People's Rights, and visually all the constitution of these member states recognize the Charter as having a fundamental normative value in constitutional democracies and the law and the rule of law in the region. As a consequence of the universal recognition of the Charter, the authority and legitimacy of the African Court should therefore be almost anonymous, recognized by states. However, there's very little national response to the decisions of the African Court, which is another cause for concern. The key issue arising from this disconnect trend between the African Court and national are manifold. For example, when the African Court rules on a death penalty, which is recognized as a cross-cutting issue in the region, should governments not be expected to undertake the necessary reforms to prevent litigation in which the court would ultimately give judgment against the state concerned? Similarly, when a national court adjudicates on the issue of freedom of expression, on which the African court has already made a pronouncement, should the municipal judge not be guided by the source of interpretation provided by the African court, given that the African Charter is already part of the national law? It is evident that in adopting the African Charter and establishing the African Court, the ultimate aim of the African Union is precisely that the African Court should serve as both a supervisor and harmonizer of the application by national actors of the region principle agreed upon by the states. In short, when decisions of the African Court remain without effect or generate little impact, it is the very vision of the African Union that is betrayed, and the very principles of the Constitutive Act of the Union that remain dead letters. Indeed, the African Court is the main tool for assessing the effectiveness of state compliance with their commitment not only to human rights, but also increasingly to democracy, governance, and the rule of law. Your Excellencies, ladies and gentlemen, without dwelling into the substantive questions to be discussed during the conference, I would simply like to remind us of the main issues that have motivated the holding of this conference. The issue of enforcement and the impact of international courts decision has been widely debated. In reflecting on it again, we must seek, therefore, to shape innovative recommendations. We are bound to formulate solutions that fit the African context, and which cannot ignore the socio-political realities of the continent, even if the law must remain our compass. Given the quality and diversity of the resource persons invited to this meeting, I have no doubt that our deliberations will lead to conclusions that hold the potential to change the status quo. I would like to assure you that as part of its new approach to cooperation with states, the African Court is committed to carefully examine the conclusions and recommendation of this conference on the occasion of exchanges it will be holding with the states in the mandate and operation of the court within the African Union framework. On these notes of comments, I wish us fruitful deliberations and thank you for your kind attention.
Nous allons maintenant appeler son Excellence Salomon Ayele Derso pour son mot prononcé au nom des institutions continentales des droits de l'homme. On me dit de reprendre. Alors, nous allons, après avoir remercié la présidente, appeler son Excellence Salomon Ayele Derso pour son mot prononcé au nom des institutions continentales des droits de l'homme. Excellence Salomon, il est sans doute dans la salle.
Thank you very much. Thank you very much, moderator. I'm joined virtually.
Ok, il est en ligne. Ah, ok. Merci bien. Je ne vous voyais pas, vous êtes bien là. Merci. Vous avez la parole, cher Salomon.
Thank you very much, Vice President on Human and People's Rights, and moderator of it, Madam, the African Court on Human and excellent representatives parties, the African Human Rights. It is a pleasure to join you today for this important conference organized by People's Rights. Indeed, Madam President pointed out, implementation of the African human organs is a prerequisite for the realization and full enjoyment the rights and enshrined in the African Charter of Human Rights and the various instruments supplementing the Human and People's Rights. This year, 20 marks the 40 years anniversary of the African Charter on Human and People's Rights, the treaty on which the African human is founded. As we mark the anniversary, there is nothing important to ask and examine where the journey towards dignity, equality, and justice in Africa. These are the values between the African human as an initiative in the African rights embodied in the Constitutive Act of Africa. The state of implementation of decision of the African Court was pointed out by Madam President, and indeed that of my own Commission on Human and People's, as well as the African Committee of Experts and Welfare of the Child, leaves a lot to be desired. Despite the 15 years journey of the Human and People's Rights and the 40-year journey of the Human and People's Rights, we are behind in terms of translate promise the obligations by member states of the Union into the lived reality, the masses of our people. On the lack of the decision of the African Court, and indeed the African Commission and that of the Committee of Experts, is one of the most serious failures that impede the effective operations of the African human rights system, that also casts doubt on the legitimacy of the very promise that states parties to the African Charter and other supplementary human rights instruments have made. If the promise for dignity, freedom, equality, liberty, and justice that member states have made by freely binding themselves in these instruments is not translated into reality through, among others, complying with the decisions of African human rights institutions, people who are deprived of and denied their inherent rights would be forced to run away from pursuing their legitimate rights through institutions of law, such as the African Court and the African Commission and the African Committee, into alternative options and avenues, including through protests on the streets and other forms of seeking justice trying to protect their dignity. The only way and the right way for ensuring and avoiding the crisis of legitimacy facing the African human rights system, and indeed the crisis of legitimacy afflicting states parties to the African Charter on Human and People's Rights and the African Union system broadly, is to ensure that the states reaffirm their commitment to the obligations that they have assumed under the various human rights instruments. And one way of demonstrating this reaffirmation of their commitment is by working together with the African human rights institutions and by working closely with them to give effect to the decisions and recommendations of the African human rights institutions. As we deliberate on the state of compliance and implementation of decisions of the African Court, it is therefore of paramount importance that we ask difficult questions, including, apart from the very underwhelming level of implementation of decisions and recommendations of the African human rights system, we have to ask why after so many years of engagement in the African human rights system, we have this low level of implementation of decisions. And what is the level of connection between the African human rights system on the one hand and the states parties on the other hand? What role do various stakeholders have to play in order to enhance the effective implementation of decisions of the African Court and those of other human rights bodies of the African Union, like the African Commission on Human and People's Rights, stakeholders such as national human rights institutions, civil society organizations, the media, law schools, the bar associations, and what is the kind of relationship that we as the African human rights institutions need to build with all these critical sectors of the African public, whose role would play a very important role, a very important contribution towards achieving the ideals underpinning the African human rights system. I do hope that this conference will provide us with very practical insights and proposals on how we can elevate the level of implementation of the decisions of the African Court, those of the African Commission on Human and People's Rights, and the African Committee of Experts on the Rights and Welfare of the Child, so that we will avoid the worst of non-compliance with these decisions and indeed a failure to uphold the promises of the African Charter on Human and People's Rights. I sincerely apologize that I was not able to join you in person in the beautiful city of Dar es Salaam, but I can assure you that I would be following the deliberations and the outcome of this conference very closely. And I look forward to and wish you all a very productive and successful conference. Thank you very much for your kind attention.
De l'Union africaine. Monsieur Adjaka, vous avez la parole.
Merci, monsieur le modérateur. Excellence, monsieur le ministre d'État, à la présidence de Zanzibar, chargée de la justice. Honorable Dr Solomon Ayele Desso, président de la Commission africaine des droits de l'homme et des peuples, porte-parole des institutions continentales des droits de l'homme. Excellence, Madame la Présidente de la Cour africaine des droits de l'homme et des peuples, honorable juge de la Cour africaine des droits de l'homme et des peuples, distingués invités, tout protocole respecté, Mesdames et Messieurs, créé à Ouagadougou, au Burkina Faso, le 9 juin 1998, par l'adoption du protocole relatif et entré en fonction en 2006, la Cour africaine des droits de l'homme et des peuples commémore ses 15 années d'exercice. Au nom des États partis au protocole de Ouagadougou, je souhaite à Madame la Présidente et à toute son équipe une fructueuse commémoration. Madame la Présidente, comme il résulte fort éloquemment de l'intitulé du thème que vous avez retenu, la présente conférence vise à apprécier l'impact des décisions de la Cour africaine des droits de l'homme et des peuples sur la situation des droits humains en Afrique. Mesdames et messieurs, l'exécution d'une décision de justice, loin d'être une simple formalité, est l'étalon à l'aune de laquelle s'apprécie la légitimité d'une juridiction. Elle sert de lucane d'évaluation de l'accès des justiciables à la justice. Si au plan national, en particulier, l'exécution des décisions judiciaires n'est pas un pari facile à gagner, au plan continental, elle relève d'un travail de bénédictin. Réfléchis donc sur l'exécution des décisions de la Cour africaine des droits de l'homme et des peuples et évaluer leur impact est une problématique aussi pertinente que difficile à épuiser. S'agissant de l'exécution des décisions de la Cour africaine des droits de l'homme et des peuples, le rapport d'activité présenté en décembre 2020 aux instances délibérantes de l'Union africaine par la plus haute juridiction panafricaine en matière de protection des droits de l'homme révèle que de 2006 à 2020, la Cour a été saisie d'un total de 300 requêtes et de 14 demandes d'avis consultatifs. Elle a rendu 106 arrêts, 90 ordonnances et finalisé 12 demandes d'avis consultatifs. Sur la centaine d'arrêts et d'ordonnances rendues, seul un arrêt a été exécuté, soit un taux d'exécution de 7%. Nos recherches ont permis de savoir que 18% des décisions de la Cour ont été partiellement exécutées et 75% n'ont pas enregistré de début d'exécution. Ces statistiques, loin d'être encourageantes, interpellent au premier chef la Cour sur l'efficacité de son office. Concrètement, l'on peut se demander pourquoi les décisions de la Cour, loin d'inciter les États membres de l'Union africaine à adhérer au protocole de Ouagadougou, les contraignent plutôt à s'abstenir ou, au pire des cas, à retirer à la Cour leur déclaration de compétence. Pourquoi la Cour de justice de la CEDEAO, la Cour européenne des droits de l'homme et la Cour interaméricaine ont-elles des fortunes plus reluisantes que celles de la Cour africaine des droits de l'homme et des peuples? Madame la Présidente, Mesdames et Messieurs, ces questions nous fondent à affirmer que la Cour africaine des droits de l'homme et des peuples est la principale source de l'inexécution de ces décisions. Son mode opératoire justifie le tableau peu glorieux que présente l'état de ses relations avec les États partis au protocole de Ouagadougou. Si nul ne conteste la primauté du droit international sur le droit interne et le caractère exécutoire des décisions de la Cour, il n'en demeure pas moins important de souligner qu'une décision de justice ne peut être mise à fin que lorsqu'elle est exécutable, autrement dit, compatible avec l'environnement juridique dans lequel elle est rendue. L'inexécutabilité des décisions de la Cour africaine des droits de l'homme et des peuples résulte de la violation du principe de l'épuisement des voies de recours internes, de la méconnaissance des réalités juridiques internes des États, de l'immiscion dans les processus électoraux des États, de la propension à recourir aux mesures provisoires, du peu d'égards vis-à-vis des États partis au procès et surtout la tendance à leur infliger au profit des particuliers des condamnations pécuniaires faramineuses et suicidaires. Mesdames et messieurs, si nous sommes d'avis que les conventions ratifiées engagent les États, il est une évidence qu'aucun État parti à une convention ne peut rester lié lorsque la mise en œuvre de celle-ci fait planer une menace persistante sur son existence. Entre rester engagé et péril et se délier pour survivre, aucun État n'hésiterait à faire la seconde option. C'est dans ce sens qu'il convient, à mon humble avis, de comprendre le choix vital fait en l'espace de 4 ans par le Rwanda, la Tanzanie, le Bénin et la Côte d'Ivoire de retirer à la Cour leur déclaration de compétence. La Cour s'étant unilatéralement octroyé le 1er septembre 2020 les pouvoirs de juge de l'exécution en lieu et place du Conseil exécutif et de la conférence des chefs d'État et de gouvernement à travers la modification de son règlement intérieur en ses articles 80 et 81, il est fort à craindre que la situation se dégrade davantage par le retrait de certains États membres de la Cour du protocole de Ouagadougou. Un tel rétropédalage peut aisément se comprendre, d'autant plus que seuls 31 États sur les 55 États membres de l'Union africaine ont ratifié le dit protocole. Mieux, aussi curieux et paradoxal que cela puisse paraître, à la tribune des instances délibérantes, l'ensemble des États de l'Union statuent sur l'inexécution des décisions de la Cour et préconisent des mesures contre des États qui, non seulement ont ratifié le protocole de Ouagadougou, mais surtout souscrit la déclaration de compétences permettant aux individus et aux ONG de les attraire directement devant la Cour. C'est pour éviter ce recul préjudiciable à la protection des droits de l'homme et soucieux de réinvestir la Cour africaine des droits de l'homme et des peuples de la confiance des États que le Bénin, mon pays, a élaboré et soumis à la conférence de l'Union africaine des propositions concrètes de réformes courageuses de la Cour sur lesquelles il sollicite d'ores et déjà votre soutien massif. C'est sur cette note d'espoir que je nous souhaite de fructueuses réflexions et plein succès à nos travaux. Vive la Cour africaine des droits de l'homme et des peuples. Je vous remercie.
Merci Michel Adjaka, chef de cabinet du ministère de la Justice et garde des Sceaux de la République du Bénin, qui annonce déjà les débats qui vont avoir lieu sans doute et les juges vont répondre à tous ces éléments. On va poursuivre notre programme avec le mot discours et l'ouverture officielle par l'honorable Haroun Ali Souleyman, ministre d'État président, chargé des questions constitutionnelles, juridiques et de bonne gouvernance, représentant le président du gouvernement révolutionnaire de Zanzibar. Son Excellence, vous avez la parole.
Good morning and Assalamu alaikum wa rahmatullahi wa barakatuh. I'm here on behalf of the President of Zanzibar, Dr. Hussein Mwinyi, who is not able to join you today because of other commitment, and apologies from himself. But all the speech I'm going to read here have been given by himself. Therefore, all the words are here, I'm going to read on his behalf. Honorable Imani Aboud, President of African Court, and all judges of the African Court on Human and People's Rights, Vice Chairman and Moderator, the Chief of Staff, I recognize the former Chief Justice of Tanzania, Honorable Onwar Chande. Also, I recognize the presence of the Chief Secretary of the Revolutionary Government of Zanzibar, Madam Zena Saidi, representing from various institutions and organizations present here today, distinguished guests, ladies and gentlemen. It gives me great pleasure and honor to officiate at this important conference on the implementation and impact of decision of African Court on Human and People's Rights. Allow me to begin my address by expressing my personal gratitude to the African Court on Human and People's Rights, and in particular to the President of the Court, Honorable Justice Imani Aboud, not only for inviting me to be part of this important conference, but also for the effort taken to convene this continental gathering of eminent personalities to reflect on the implementation of impact of decision of the court. Before I proceed, I take this opportunity to welcome you to Dar es Salaam. It is my hope that after the conference, you get time to explore and join the many delights that Dar es Salaam and the surrounding areas have to offer. Here in Tanzania, we pride ourselves on our hospitality, and I can assure that wherever you go, you will be greeted by a warm and welcoming smiles. Once again, karibuni Tanzania, and feel at home. Distinguished participants, in many of African traditions, we hold firm and believe that problems are best solved when several minds are brought together to reflect on a particular issue. I thus take comfort from the fact that it is always from working collectively that the best solutions for the problems emerge. It is important to remain aware of the reason that motivated the creation of the court. The objectives of creating the court shed light on why the implementation of the decisions of the court remains very important. As may be recalled, at the dawn of the African human rights system, member states of the then Organization of African Unity established the African Commission on Human and People's Rights as the only supervisory mechanism charged with overseeing the implementation of African Charter on the Human and People's Rights. The Commission, needless to point out, remained a quasi-judicial institution, and this meant that the African continent, before the establishment of the court, had no continent-wide judiciary body with the mandate to issue binding decisions in cases involving human rights violations. The lack of judiciary institution to monitor and enforce human rights was finally rectified by adoption in 1998 of a protocol of the African Charter establishing the African Court. This protocol, we all may know, entered into force in 2004, and the court itself was operationalized in 2006. Distinguished participants, it is my view the adoption of the protocol was very firm statement on the part of the African countries in support of the cause of human rights. In adopting the protocol establishment, the court, therefore, African countries clearly indicated that to the world at large that they took human rights protection and promotion seriously. In all this, the loudest statement made by African countries was that, unlike times gone by, they were now willing to subject themselves to scrutiny in terms of compliance with the human rights standards. At a more practical level, African countries may, by establishing the court, and also acknowledge that there were some deficiencies in using the African Commission, a quasi-judicial body, as the only human rights supervisory mechanism to the continent. It is therefore not at all surprising that the protocol establishing the court expressively directs that the court and the African Commission must always operate on the basis of complementarity. In my view, this complementarity is meant to maximize the best from both institutions and thereby contribute to the protection and promotion of human rights across the continent. Distinguished participants, this year, the court is celebrating 15 years since it became operational. In these 15 years, the court has developed a remarkable jurisprudence in respect of many rights protected in the Charter. I dare suggest that compared to other regional human rights systems, the court has moved at a very brisk pace in its 15 years. The way it has been operating in something that all of us as Africans should be proud of. However, as would be expected of any institution, the court has faced a number of challenges in its life and operation. Those challenges are part of the theme of this gathering. As it has been revealed in the court annual activity reports to the African Union that the implementation of the decision of the court by state parties remains very low. As a matter of fact, recent data from the court suggests that the compliance within its decision stands at a paltry 7% only. It is evident that this level of non-compliance with the decision of the court is nothing to be proud of. Given the status of non-implementation of the decision of the court, I believe this conference has come at a very appropriate moment. Once again, I commend the African Court for bringing delegates from all over Africa to reflect on this very important issue. It is my hope that it is in the course of deliberations during the conference, delegates will engage each other openly and constructively and ultimately and come up with a realistic solutions of improving the implementation of the decision of the court and overcome the challenges we face. Distinguished guests, delegates, the African Court is our own institution. We created it. I believe, therefore, that it is the interest of all of us as Africans to make sure that this institution does not fail to meet its objective. I dare suggest that to all of us present here that there is no gain for Africa if the court becomes a failure or an institution that does not practically contribute to the protection and promotion of the human rights across the Africa. In this regard, I wish to point out that one important way in which states can contribute towards the success of the African Court is by fully implementing its decision. This will not only guarantee the litigants before the court the fruits of their legislation, but will also show to the whole world that African countries now take the protection and promotion of the human rights seriously. I would also like to invite delegates to this gathering to reflect on not so often mentioned dimension to the implementation of the decision of the court. In this regard, I believe it is important to always bear in mind that the human rights standards that African court applies in its decisions are standards with the continental application, almost all of them having been adopted within the African Union. Given this, I believe there is a strong case to be made for all African countries, even those that are not parties to the protocol established the court, to pay attention to the court's articulation and restatements of the various human rights standards. I would thus urge African countries to be proactive in their engagement with the jurisprudence of the court to ensure that all their laws are compliant to the standards of the Charter and other continental human rights standards. In my view, it is not always necessary for the state to be defended before the court in order for it to take steps to align its laws and practices within the international human rights standard. States must simply pay adequate attention to the decision of the court, and where appropriate, they can be emptively realign their laws without waiting for the judgment to be rendered against them. I'm sure in the course of the next 3 days, the details in relation to the implementation of the court's decision will be thoroughly discussed and examined. I again invite you to be candid in your deliberation, to be creative and innovative in your proposal for the reform. Let us make sure that we implement the decisions accordingly, knowing that the court whose decisions are not implemented loses its credibility and legitimacy. I again reiterate myself that the court was a very useful addition to the African human rights system, and it would be self-defeating to allow the court to fail due to the state's failure to implement its decision. I also urge states present here to learn from each other and on the best practices for the engagement within the court, and particularly in relation to the implementation of the decision of the court. Once again, I wish you very fruitful deliberation and sincerely hope that we will make the court the pride of Africa. Thank you very much. Asante sana kwa kusikiliza.
Merci, Excellence Haroun Ali Salomon. Nous allons à présent passer à un exercice que le greffe connaît très bien. Donc, je vais donner la parole au greffier adjoint Diallo. Merci.
Merci beaucoup, Monsieur le Président. Merci à tous les intervenants. Maintenant, nous sommes à la fin de la cérémonie d'ouverture. Nous allons prendre une petite pause dans un premier temps pour aller faire une photo de groupe de participants. Les agents de protocole vont conduire les honorables à la sortie de la salle dans le grand hall où on fera une photo de groupe. Ensuite, après cela, nous aurons une petite pause pour prendre du café, du thé, de rafraîchissement avant de revenir dans la salle pour la suite de la conférence. Donc, j'invite les agents de protocole qui sont dans la salle à conduire les honorables là où aura lieu la photo. Je vous remercie.
Excellencies, ladies and gentlemen, I take the floor to advise each of you to carry your personal belongings, because the hall is going to be reset for another seating arrangement, and therefore keep your personal assets with you. And when you come back, you shall identify your seat by name. We are going to put names. Thank you so much. Excellences, Mesdames, Messieurs, pour plus de précautions, je vous conseillerais de prendre vos effets personnels. On va réaménager la salle et vous allez identifier votre siège par le nom. Merci beaucoup. Bonne pause café. The group picture is taken at the main entrance. We are all going to the main entrance for the group picture. Thank you. La photo du groupe de tous les participants va être prise devant l'entrée principale de la salle de conférence. Merci beaucoup.